Hello everyone, welcome to MVC Academy. This is Santosh Koka, Faculty of Polity and Governance. Today we will discuss very important topic, that is criminalization of politics, right? So first of all, we have to understand that in India, whether it is a democratic country, so many criminals are entered into the politics. That is the main concern as of now we are facing, right? So many cases are pending regarding the criminalization of politics. So especially ADR report, so Administration or Association for Democratic Reforms report is clearly telling the important facts related to criminals entered into the politics, right? So what are the important topic, what is the meaning of criminalization of politics, and also what are the important impacts and also important facts related to the report we have to see, and what are the challenges we have been facing related to this particular issue, and also what is the way forward for this means what is the solution for this problem also we have to understand, right? First of all, little overview of criminalization of politics. What is criminalization of politics? First of all, right, criminals just entered into politics, means from the society point of view, if you know the society point of view, or from the political party point of view, both are including the particular criminals into politics. That is the main concern here. So whether the voter is completely knowing about the particular candidate, even though he is a criminal, so but he is still admiring that person. That is the main important issue here, right? That also here, if you understand the political party concern also, political party point of view also, as a criminal entered into the politics as a contested politician, so he has the power, muscle power, he has the money power, and also criminal mentality, right? So it is also worthyful for that particular political party. From the point of view of political party also, they are entering or they are encouraging the persons, or they are welcoming those persons into the political party. That is also main concern. So first of all, increasing the trend of candidates with criminal records in elections, that is the main important issue. So democratic concern about quality of representation. So because of this concern, so from the Association for Democratic Reforms, what is the report clearly says that the facts, important facts related to almost 44% of MPs are completely criminals into the politics, right? So this sort of main important. Other than the 25% of persons who are entered as a criminals into the politics, they have the criminal serious or heinous crimes, right? That is also very important fact here. So democratic concern about quality of representation is here. So and also voter behavior also often supporting candidates with criminal background, right? So they are completely supporting who has criminal background. That is the main important issue here. Other than that, party calculations prioritizing winnability over character. So who has the criminal mentality or criminal power or muscle power or whatever we have, money power, they only winning the elections. That is the main political party calculations also. That is also very important concern here. So systematic problem requiring comprehensive reforms also here. We have to take the important stringent reforms here to tackle this issue. So and also international comparison showing India's unique challenge. So if you compare with other particular USA, whether it is USA or any other country, there is some sort of corruption, but criminals are entering into the particular field, means political field. It is not that much good for our entire governance, right? So that is the important issue here. So next we have to understand the statistics on criminalization of 2024 data. If you observe the Association for Democratic Reforms 2024 data, you can clearly observe that 44% of Lok Sabha MPs have declared criminal cases, right? So that is the main important thing. And also 25% here, 25% have serious criminal cases. Serious criminal cases means here murder type of things, or rape, kidnapping, these type of fellows or these type of accused fellows are entering into the politics. We are encouraging them. That is the main issue here. And also increasing trend over successive elections since 2004. Right? Since 2004, it has been increased rapidly. That is also very important concern. So state variations with some states showing higher percentage. If you take Andhra Pradesh or Telangana, if you take the Madhya Pradesh or Uttar Pradesh, even state-wise also, the higher percentage has been differentiated, right? So even though we have in Andhra Pradesh and Telangana so many criminals entered into politics, and also party-wise analysis showing cross-party nature of problem. This is a cross-party nature of problem, not only one party nature here, right? And also wealth correlation between criminal cases and candidate assets. It is a wealth correlation between criminal cases and candidate assets. Here, money power and muscle power is the main important thing to get the vote bank. That is, the political party also is very much interested to entering or welcoming these persons into the political party, right? So next, if you observe the reasons, what are the reasons for criminalization here? Vote bank politics based on caste, religion and community consideration. Vote bank policies based on caste, religion and community considerations is the very much important reason, foremost reason. And also money power and high cost of elections favoring wealthy criminals. Money power and also high cost of elections. So every elections they are spending so much. Even though we have been following the earlier we have the electoral bond scheme, right? So many issues or initiatives were there, but still we have been spending high cost of elections here. So and also muscle power for booth capturing and voter intimidation. This is also very important. The candidate who has the money power or muscle power, he will become the important personality in that particular area. He only is getting the elections, right? So that is the main important. Slow judicial process with low conviction rates of politicians also. So we have been seeing since 2004 so many cases have been pending, right, in the judiciary part, but they are completely slow. Judicial process is a hindering task to gain our governance, right? And also party pragmatism, prioritizing electoral success over candidate charisma. That is also very important here. So character especially, right? So candidate character, more than candidate character, they are completely depending on their money power and criminal cases who have entered into the criminalization of politics, etc. Right? So voter acceptance due to lack of alternative or development promises, especially they don't have any alternative other than that particular politician, right? So they have just completely supporting the particular person to have the development in that particular area, right? So they have only one alternative. We have to aware them. We have so many alternatives, right? So for example, if they are having so many problems with such candidate, they can opt for nota, right? None of the above. But nobody knows about nota, right? Nobody knows about nota. That is also very much important thing. So next, if you observe the next important thing, Supreme Court interventions on criminalization. Supreme Court interventions on criminalization. Right? We have certain challenges, we have certain statistics related to criminalization of politics. So what are the Supreme Court interventions on criminalization here? So generally, we have seen there are so many explicitly mentioned provisions in the Constitution, that is completely explicitly mentioned in the Constitution, but implicitly some judiciary interventions will be there. Means that is called a judiciary interpretations, right? So some sort of information is not in the Constitution, that is Constitution explicitly not mentioned in the Constitution. From those perspective, Supreme Court or other courts, especially Supreme Court only, judiciary interpretations related to certain rights violation things or other important things, they can interpret. Judiciary, they can intervene related to issues, right? So here Supreme Court interventions on criminalization, if you observe the ADR versus Union of India 2002, mandatory disclosure of criminal antecedents. So in 2002 itself, the Supreme Court clearly says this in this case. Association for Democratic Rights or Democratic Reforms versus Union of India, mandatory disclosure. They have to disclose their important affidavits or criminal cases, whatever they have, right, before contesting into the elections. That is the main mandatory thing. And also if you observe the Lilly Thomas versus Union of India 2013 case, in this also Supreme Court clearly says that immediate disqualification on the conviction. Wherever the particular MPs, right, are having some sort of conviction, right, related to this particular criminalization of politics especially, right, completely they disqualified, right, according to the Lilly Thomas versus of Union of India. And also we have recent directions, especially from the 2020 to 24, public disclosure of criminal records by parties itself, right. So parties itself, they have to disclose the complete criminal records of their candidatures, right. So here to public disclosure, this is very important here, right. These are the recent directions. And also reasoning requirement for selecting candidates with criminal background. Why those political parties are encouraging, or political parties are welcoming those candidates who have the criminal cases, that is the main important thing. Newspaper publication of criminal antecedents mandated. So if there are any background of criminals or certain cases they are pending in the before the judiciary, compulsorily before elections only they have to publish in newspaper itself. So previously we have seen so many newspaper articles regarding the Andhra Pradesh and Telangana government related politicians who have criminal cases, right. So and also social media disclosure for wider public awareness. Not only media, we have social media as of now. We are social media disclosure also very important for wider public awareness. So many youth or some sort of students or aspirants are not studying newspapers, right, for them. So they can enjoy, or they can particularly aware from this particular related things if they are completely disclosed in the social media things, right. So that is the Supreme Court observations or interventions related to criminalization. So next we have to understand the Lilly Thomas case impact. What is the impact of Lilly Thomas case here? So completely it was taken under the in 2013 itself. So in this case, especially section 8 clause 4 of RPA 1951, if you take Representation of People Act, right. So here it struck down by the Supreme Court. What is section 8 clause 4 here? Immediate disqualification on conviction with the 2+ years sentences. Immediate disqualification on conviction with the 2+ years sentence. Who are having some sort of criminalization of politics, means criminal cases entered into the politics. Some sort of exemptions also are there in the section 8 clause 4 of RPA 1981, right. So for this Supreme Court clearly mentioned that who have certain conviction immediately disqualified, right. So with the 2+ years, anybody is having 2+ years conviction rate or conviction time, then immediate disqualification will be taken, right. So no protection through appeal filing within 3 months. Within 3 months there will be no protection regarding the bails or something, right. So deterrent effect on politicians with the pending criminal cases also. Deterrent effect on politicians with the pending criminal cases. Who are having pending criminal cases, deterrent effect will be there on politicians. And also constitutional principle of clean governance here upheld in this special case, that is Lilly Thomas case in 2013, right. So implementation challenges in practice due to judicial delays. So we have certain powers, we have certain provisions, we have certain schemes, laws and policies, but what is the importance of implementation? That is the main lacking challenge here, right. So we have to focus on the judicial delays. We have been pending so many cases in judiciary. That is the main challenge we have been facing. And also what are the proposed reforms for decriminalization? Criminalization means criminals are entered into the politics, but decriminalization means we have to remove them from the politics. That is the name itself. Fast track courts for cases involving elected representatives. There should be having the fast track courts, right. That is the main important way forward solution we have to follow. And also time bound trials with strict deadlines for completion. So many pending cases are there. So in the judiciary front, so we have to fast trial, means fast track courts should be there, and also time bound trials with strict deadlines for completion. The cases should be completed within short time, and also disqualification for charges in heinous crimes during trial. So almost 25, according to our ADR report, almost 25 of our MPs are having the serious or heinous crimes, right? So that's why we have to remove them, or we have to disqualify for charges in heinous crimes during the trial. And also negative voting options like nota strengthening. So people are not aware about nota. So without having no alternative, means without having other alternative, they are completely voting the particular person who has the pending cases or criminals entered into the politics. That is the main reason we have to aware them. We have the other choice, that is nota, none of the above, right? So they can choose negative voting options, right? Next, party funding transparency to reduce criminal money influence. Party funding transparency to reduce criminal money influence. We have been struck down already electoral bonds, right? So for this, we have to follow certain things. We have internationally some practices, state funding. We have been following in internationally. They have been following some important funding methods like state funding, right? So we can approach these type of issues after struck down by the Supreme Court. Electoral bond scheme completely struck down by the Supreme Court, right? So now we don't have any funding mechanism. We can follow the state funding. So many countries followed internationally, right? So state funding means government only fund for the elections, right? It will be beneficial to the particular independent candidature and also who are genuine persons, right? So, and also voter education about candidate backgrounds and choices. Voter education is very important. Why? Because here candidate background need to be show before elections itself. They have to show each and everything related to that particular candidate, and also choices, alternatives, right? So other than that person, they don't know anyone, right? We have to aware them. So many options are there. We have independent candidates will be there. So we can provide certain information to them, right? So whether they are having the particular character or good character or not bad character, we have to show them, right? Then only they can use this power of voting, right? Next, this is the criminalization of politics part here. So this is main hurdle to our good governance. We have to remove them in our political system.